Hi, everyone. Welcome to another episode of the Ask Amity Show, and Happy New Year. Now we're in the year of 2021. So today we wanted to talk about a new law that's going to take effect soon. So this one is called the Prop 19. So currently, parents transferring properties, real properties to their children, there's what's called a parent-to-child exclusion. That can be allow the transfer to be exempt from reassessment of property tax. So currently, if parents want to leave their children their property, they can transfer it to their children, and the property tax may not necessarily increase because they can file for this exclusion. However, starting in February 16th of 2021, which is coming up pretty soon, Prop 19 is going to take effect. And so this means that the new law says if a parent is to transfer a property to a child, whether or not it be by gift or by inheritance, the child must claim this property, number one, as their primary residence, and the property has to be less than $1 million in value in order for the property tax to be exempt from reassessment. So there is a certain condition now that children must follow in order to claim this reassessment exclusion. So if the child has multiple properties or is somehow, unable to claim your parents' property as a primary residence, then it's going to be reassessed to the value of the time of the transfer. So this may, make it a little bit harder for children to keep the residence, especially if the property has gone up in value significantly from the time the parents purchased it. So something to really think about, your long-term goals, whether or not you're going to intend to keep your parents' property or not. If you're going to sell it, then, maybe property tax isn't too big of an issue for you. But if you're trying to keep this property, then, you want to think about whether or not maybe right now is a good time to get it transferred while this parent-to-child exclusion and exemption is still in effect. So just something to keep in mind. February 16th, 2021 is an important date to remember.
Another date to remember is April 1st, 2021. So this is the second part of Prop 19. This is basically saying that anyone over 55 years of age, disabled, or a victim of wildlife, natural disaster may transfer their assessed value of a California primary residence to a newly purchased or newly constructed replacement primary residence in any county within California. So prior to Prop 19, this section, this part of the law was stating that you could, if you're over the age of 55, you could transfer your basis if you purchase a new property. But the law changes, what the law changes is that you can actually do this 3 times now. Prior to that, you can only do it once. And now you can actually do this with a property that is in higher value than the property that you sold. So prior to it, you can only do it to a property that you purchased, and the property needs to be less than the value of the property you sold. So now you can do it to property that is higher. And also just keep in mind that you must do this within 2 years from the date of the of selling your prior home. So that's all for now. That's Prop 19 in a nutshell. If you'd like more information on Prop 19, whether it is to keeping the basis of that property value, or if you're over 55 or disabled or a victim of wildlife, natural disaster, and you'd like to learn more about that portion of Prop 19, please give us a call. I'm more than happy to give you a free consultation regarding Prop 19. Other than that, see you next time.